All right, now I know many of you may want to pose questions, and we very much want that to be a part of this program. So I do ask that you wait for a microphone. We have two microphone carriers here, and when you get the microphone, please do say your name and your affiliation. We'll start with this gentleman here.
My name is Joe Hennessy from the law firm of Bynes, Goldberg & Hennessy in Chevy Chase, Maryland. I have a question for Mr. Koh related to the rule of law, your role as the conscience of the administration on legal matters, and your role as a spokesman of the administration. On February 2nd, Dennis Blair, the Director of National Intelligence, to the House of Representatives to announce that the administration had drawn up rules that will govern the killing of American citizens overseas. This is nothing short of astonishing, given that the Supreme Court, every time we presented with issues related to the applicability of the Fifth and the 14th Amendments to the Constitution, have ruled that they do in fact apply to American citizens overseas. And the United States is party to treaties which uniformly condemn the concept of extrajudicial killings. My question for you is, can you share with us what those procedures are? And do they, at a minimum, require the administration to present evidence to the judicial branch? And do they, at a minimum, require or allow the person who is going to be targeted for the killing to contest the factual allegations by the administration?
Well, look, I'm not going to get into the details. It does seem that the President made clear, and said it in his Nobel lecture, that while we are confronting an adversary that's abiding by no rules, we are continuing to obey the rules of law in the ways that we fight. And that's a deep commitment being carried out by this administration on an interagency basis. That means a commitment both to international law and to the specific laws of war. Now, your characterization of what the Director of National Intelligence said is not my understanding of how it was put. I think there is an issue as to exactly how we are going to be conducting the kinds of military operations that we're engaged in with individuals with whom we are in armed conflict. And that what was described there was a set of procedures that have been are still being worked on, as I understand it, for the purpose of addressing this question within the framework of the laws of war. So I think that's all I'm going to say about it. I think that the key of it is possible, it seems to us, to deal with the threats that we face within the framework of the laws of war. That's part of my job, and that's what I do every single day. That is both within the framework of domestic law and within the framework of international law. If it ever came to the point where I believed that those rules were being violated, I would resign. And I'm frankly someone who has both served in Democratic and Republican administrations, and I have sued both Democratic and Republican administrations for violations of the rule of law. More than that, I have a lifelong job. And to me, obedience with the law is why I'm here. And if I ever believed that this administration were not obeying the law, I would leave. So since I'm still here, you can draw your own conclusions.
Yes, sir.
My name is Mark Feldman.
I'd like to ask legal advisor, Mr. Carlin, thank you for coming to us today, to talk a little bit about the question of the application. To what extent does this administration support the notion that our troubles, put it this way, the threats that we face from terrorists of all kinds, including terrorists who may perform acts in the United States, are governed by the rules of warfare? I'm particularly interested to know whether what the administration's view is of the original Bush military order number 13, which suggests the potential for suspending the criminal justice system, that is to say, substituting military justice for criminal proceedings in the cases of terrorist suspects in the United States. In the context, for example, of the underpants bomber, I haven't heard anyone in the public debate say that the prosecution in a military commission would be unconstitutional. And yet I tell my students, I think that's better argument that possibly militant Trump's hero. But the broader question is, how broad does the law of war apply to all threats? Battlefield in Afghanistan being one thing, domestic terror another, international entry. I'm very interested in what you can share with us on that.
Well, I think that the President set forth the framework of his response in the speech that he gave at the National Archives on May 21st. What he described was a combination of responses, military responses to military events overseas, the possibility of Article III trials for persons engaged in ordinary criminal activity. Richard Reed, the shoe bomber, famously said when he got off the plane in Boston, where are the television cameras? And the sheriff arresting him said, well, you're just a criminal. And this was repeated by Judge Young at his sentencing proceeding. There are offenses which are committed against U.S. entities on U.S. soil, for which there are many eyewitnesses. A process of prosecuting someone through an Article III court is a time-honored method for dealing with such individuals. Hundreds of cases were done in the Article III courts against such terrorists, and that remains an available method of response. The President also suggested that military commissions could be used if there were an amendment of the Military Commissions Act of 2004, I believe it was, that was recently reenacted in 2009. At this moment, the proceedings are only just now resuming, and only a few cases have been designated for those commissions. So the full range of response, I think, will be determined over time. But I think that the President made it clear that he wanted to pursue this in a way that he thought was consistent with our values, but nevertheless true to addressing our security concerns. I haven't heard anybody say that they think that the underwear bomber is not going to be convicted. I haven't heard anybody say that they don't have the evidence against him. I haven't heard anybody say that he himself hasn't given ample evidence. A time-honored way for gathering information from suspects has been through an Article III process. I mean, the prosecution of mafiosi, organized criminals, is regularly done by bringing prosecutions against operatives and getting testimony and evidence given against higher-ups. So I think that the President has made the framework clear. But again, we are in an unusual situation, and I think John would agree with this. In Afghanistan and in Iraq, we're engaged in complicated conflicts. And then we are also still, under the authorization of use of military force resolution, addressing those individuals who attacked us on September 11th in a series of networks that are changing and growing. And I think that this will call for this administration, which cares deeply. There's nothing more urgent than the protection of U.S. citizens within the framework of the law. And that's exactly what the administration is trying to do.